rail belt takes into consideration multiple factors. There is nothing in Resolution 1411 that suggests that that there's any validity whatsoever to their lease. In fact, the contrary is the case. You know, businessmen.
Why did they get an extra $300,000?
Businessmen make accommodation to businessmen to stop these kinds of things.
They make an accommodation because under the lease they were receiving lease payments, and when the lease ended they weren't, right? That's at least a piece of the accommodation.
Yeah, no.
Well, and it's remarkably consistent to the amount of the interim rates that RCA was going to allow them to charge.
I mean, I agree with the observation. Resolution 1411 makes clear that the BPMC has jurisdiction. It resolved the dispute, and it resolved the dispute against Homer. It also made clear that they made an accommodation, a financial accommodation, and that is what you want. I mean, it's the same resolution, by the way, within a couple $1,000s as the interim rate set by the RCA.
Yeah.
Okay, under a whole different theory. So I think that this is evidence that the BPMC process works, that people make accommodations to each other within this context, and don't make that sound like a bad thing, that people make accommodations to each other, that general managers trade off different ideas and try and run the rail belt utilities smoothly with regard to Bradley Power. That's a good thing. That's probably one of the major reasons the legislature entrusted them with this responsibility in the first instance. So I don't see. I think it's consistent with allowing the BPMC to do its job. I want to be sure that we don't leave. I mean, this idea that this lease had. Whoops. Are you reminding me of my time? Yeah. I just wanted to just follow up on the last thing and just say that the lease has nothing to do with Bradley Lake. You can't read it any other way. That the rights necessary for Chugach to operate the SQ line are all completely contained within this services agreement, and those rights should be honored by this court.
Good morning. My name is Dean Thompson with the law firm of Kemple, Huffman & Ellis, here representing the municipality of Anchorage, doing business as Municipal Light and Power. And our side is almost out of time, so I will be very brief. I don't have a lot to add to what Mr. Brenna stated, but Mr. Brenna is representing Chugach, Matanuska Electric, and Golden Valley Electric. I'm representing ML&P, who was instrumentally involved in the Bradley Lake agreements and wanted to have access to Bradley Lake. And I want to leave the court with a view of a Bradley Lake participant who isn't a transmission provider, isn't Homer Electric, isn't Chugach Electric. ML&P from the very beginning had to agree to a 50-year take-or-pay agreement for power that was more expensive than what they were producing at the time. And the only way ML&P would even consider a 50-year take-or-pay agreement is if it had a clear transmission path to get its Bradley Lake energy from the Kenai Peninsula to ML&P in Anchorage, and that the transmission rates were foreseeable. There were rules. There was a formula that the RCA or the APUC could not invalidate and change halfway into the process. That's what ML&P bargained for, and that's what ML&P believed that it had, not through the Chugach lease. I don't know if they even knew about the old Chugach Homer power sales lease. ML&P contracted for that through the services agreement and through the capability agreement and the other Bradley Lake agreements. So for historical perspective on this, ML&P didn't trust Chugach to not overcharge it for transmission. ML&P didn't trust Homer Electric to transmit power from Bradley Lake to Bradley Junction without rules of the road in place that would last 50 years. So MLMP sees this as a contract and statutory interpretation case. The procedures of the RCA, for the first time ever, asserting jurisdiction over a Bradley Lake transmission segment. This is the first time that ever happened. For 25 years, it worked perfectly without the RCA's intervention and with the Bradley Lake Power Project Management Committee deciding disputes. Never to be appealed to court. It worked. It worked great, and it gave all of the parties what they bargained for. So MLMP believes the Superior Court got it right, and the procedural issues are interesting because you had a DEC action and an appeal going at the same time, but ultimately MLMP sees this as a contractual and statutory interpretation question that should have been decided by the BPMC. Then if it was appealed to the courts, and the courts have the expertise to decide those issues. And that's what's happened, and that's where we are. Thank you.
Thompson. How much time does Mr. Kirian have left?
I'm going to start with the round up, which would be in 3 minutes, but they actually only went a couple seconds over 21 minutes, so
Give him 5. Mr. Thompson got a few extras, so.
Thank you, Your Honor. We'll try not to take even that much. A couple points. One is I believe there's an error. The DEC action, as Mr. Brenner refers to it, I do not believe has gone to final judgment and been subject to appeal. So first of all, that's not final. Second of all, the BPMC is not an administrative agency. It's not an appeal. If there's something defective about a BPMC resolution, that is a subject of a civil action between the parties. The RCA is not a party to that action, and any resolution of that would not be directly binding on the Commission. There's simply no issue preclusion for the Commission. And even if there were, the BPMC is not a procedure which would seem to be an adequate substitute for judicial procedure, which is a predicate to issue preclusion in front of another agency. And as we've already mentioned, the Fairbanks firefighters case says if you've got a choice between a dispute resolution process and an administrative agency, the administrative agency makes the jurisdictional decision, not the contractual process. The second issue is...
Let me ask you a question about that, though. Homer, on the other hand, is kind of bound by those things, right?
That's correct, Your Honor, and the RCA might be convinced of that. We haven't had a final order, so we haven't had an opportunity to rule on whether or not they are bound by that and what the effect of the BPMC resolution is. That's simply not an issue.
Assume for the moment that Homer is bound, and that certainly bound by the DEC. Let's assume they're bound by the DEC action that's actually final. And let's assume for the moment that they're bound by whatever happened with the management group to Resolution 14, and they haven't come to court to squabble about it. Isn't really the RCA proceeding kind of moot? I mean, because it's all based on their request for interim rates. And if they no longer really have a valid request for, or not, they didn't request interim rates, they requested rates. And if that's kind of sunk because of other things that have happened, aren't the RCA proceedings kind of mooted?
Not necessarily, Your Honor. Obviously, if the parties have, if a party has breached a contract, the other parties are certainly free to sue them. The RCA, under some circumstances, may enforce contracts. This may or may not be one of those. The RCA hasn't, at this moment, I don't believe, been asked to resolve that contract dispute. But the real fundamental issue is if the RCA has authority over this, and that can only be resolved by interpreting, first of all, the contracts and then the statute, which hasn't happened yet. Even if the results between BPMC and the RCA come out different, there's nothing defective about that. Your Police Standards Council case of a couple years ago says if the agencies have, well, if an agency and some other process, in that case an arbitrator, both have discretion in the matter, even on that, in that case where the facts were identical, it's okay for there to be two different outcomes. So the fact that BPMC may decide one thing and the RCA decides something else is not per se defective. The other thing is that I want to say, and let Mr. Krieger have some time, is the ACAP appeal was not from the interim rate order. That was Order 35, and I gave you the cites to the Commission's orders that tie back to the Supreme Court's decision. The permanent rates were set in Order 37. That was what was appealed. So the case is not really analogous to this situation and is not really a justification for what happened here, and I'm going to give Mr. Krieger the rest of the time. Thank you, Your Honor.
Mr. Krieger, he gave you 1 minute and 3 seconds.
Thank you.
Christmas.
The declaratory judgment action has been stayed. We cited in our reply brief to a website that will apparently allow the court, and I believe the court can take judicial notice of the status of that case. There has been no final order issued in that action. Therefore, it has not been appealed. And had the court in the declaratory judgment action said, well, let's consider whether or not we ought to finalize this decision, we would have argued you can't do that because on summary judgment you can't resolve extrinsic evidence, disputed facts. And in the briefing that went in front of Judge Corey in the consolidated case, we said to the extent the court is looking at this as though it's going to decide the declaratory judgment action, here is Mr. Baldwin's affidavit establishing disputed issues of fact as to the intent of the parties with respect to the services agreement. Namely, does the services agreement preclude the RCA from regulating utilities that aren't providing energy under the services agreement? What's the intent of the services agreement? Quickly, I would say that in the record, Mr. Baldwin at record 4184, 4194, his affidavit is apparent, and it's obvious that there is conflicting evidence. Certainly the trier of fact gets to decide, is this evidence conflicting or not? Those are the comments I wanted to make. Thank you, Your Honor.
Counsel, before you go, I have a question for you related to a question that I asked to Mr. Brenna, and I'm probably going to oversimplify this. My understanding was that Mr. Brenna's argument was that the lease agreement had to do with the sale of power going south, and that the services agreement had to do in connection with the sale of power going north. Is that correct?
The chronology is significant. So the Chugach-Homer lease allowed power to go south probably about 15 years prior to the Bradley Lake project, because at that point in time, Homer Electric Association was purchasing power, wasn't generating its own power, was purchasing it from CEA. So they needed to have a way to get the power that it was purchasing from CEA south to the Kenai. That's the lease. The lease is in effect when the services agreement is signed. The protesting utilities have a kind of a reverse integration clause argument that since the services agreement is silent, it must have integrated this other intent. And I don't think that happens as a matter of law. Thank you. Thank you.
So the court wants to thank all of the parties for your briefing. It was quite helpful. Thank you for your argument. We'll take the matter under advisement. We will issue a written decision at a later time. We'll be adjourned for the day.